Hello and welcome to this edition of Inside Judicial Watch. I'm your host, Jerry Dunleavy. Election integrity. With the 2016 presidential election still at the forefront of the national conversation, and with the 2018 midterms rapidly approaching, election integrity is a very important issue that is facing the nation. Much of the focus at the moment is on the impact of social media, but today Judicial Watch will be doing a deep dive on a couple of other issues surrounding election integrity: gerrymandering and issues surrounding the potential for voter fraud. And joining me today to lend his expertise and to explain what Judicial Watch is doing in court to help protect the integrity of the franchise is attorney Robert Popper, former Deputy Chief of the Voting Section, the Civil Rights Division at the Department of Justice, and Judicial Watch's Director of our Election Integrity Project. So thank you very much for joining me today, Bob.
Thanks for having me.
So before we dive into sort of what Judicial Watch is doing in court, let's give our viewers just a brief sort of synopsis, a brief history of gerrymandering, sort of where it originates, kind of how the problem has metastasized, and kind of where it stands today.
Sure. I'll make it as brief as I can, but
Sure.
it's a long history. In 1812, Elbridge Gerry, governor of Massachusetts, first created a district which was intended to help his party and hurt the other party.
Yeah.
And they crammed that word together with the salamander word, which the district sort of resembled, and they came up with gerrymander. Actually, the trick of gerrymandering is older than that, but that's sort of the genesis in this country. The way gerrymandering has always worked is that you draw district lines in a way that your opponents lose more seats than you win. And the way to do this is a little bit tricky, a little bit counterintuitive, but you pack your opponents in a few districts that they win by huge margins. And your supporters are in more districts that they win by narrower margins.
Right.
That's how gerrymandering works. And it was a rather, useful but not extremely useful procedure for a long time. There were other tools that people could use to cheat. One was lack of equal population. You could just unbalance the populations of the districts. But after the 1960s, you couldn't do that anymore because the Supreme Court handed down a series of decisions saying that you had to have equal population in districts. Now, after that, what you do is the trick I was talking about, which is you draw the districts so that you and your party win more seats. The problem of gerrymandering underwent a revolution with the advent of computers.
Now, why is that? Now, it undergoing a revolution, you're saying that it actually made it it made it far worse. It made it easier to carry out sort of these gerrymandering tactics.
Absolutely, yes. And with the advent of more accurate data about where people lived and what their voter histories were, their voter preferences, or the vote totals in particular regions, and with the ability to draw finer and finer district lines, gerrymanders became more convoluted. Sort of the mark of a gerrymander is that you've distorted district lines to achieve a partisan end. And so gerrymanders look ugly, and they're sort of famous for it. The Maryland's 3rd Congressional District was described by a federal judge, and I'll see if I can get this right, as a broken-winged pterodactyl lying prostrate across the state. Some of these districts, especially again with the advent of computer drawing of districts, are so convoluted you can't even see them at any one scale. You can zoom in and see detail, or you can zoom out and sort of see the whole district. Going back again to the 3rd district, in one place that district is 200 yards wide, one little narrow neck. At the same time, there is enough district line in the 3rd District of Maryland to reach from Montgomery County to Boston. So that's a lot of district line enclosing not a lot of area. And it's an absurdity.
And you're basically saying that because it's so narrow at some points, but so long at others that there's no way to actually there's no way to actually look at the entire district in its totality.
And to see it in its detail,
Right.
you would have to draw it so large that it wouldn't fit on a computer screen.
Right. And when you're talking about targeting voters when building these districts, I mean, so when we hear about sort of social media, that's what, campaigns will target voters based on, voter preferences and demographics and that sort of thing. But what you're saying is when these districts are being built, there's actually voter targeting of perhaps a more nefarious sort that's going on.
Yes, and what's happening is that you're taking areas that you think, for example, say it's Republicans gerrymandering Democrats, which is the case in Wisconsin. What you have is areas that are Democratic are all being coagulated or grouped together, even if it has to be by means of sort of tenuous little ribbons that reach across the state. And in those districts, the Democrats have super majorities. And then in several other districts, the Republicans win 60-40, 55-45. And the net result is more Republicans in the legislature. And the reverse, of course, is happening in Maryland, where the Democrats did the gerrymandering. In Maryland, something like 60%, that's right, 60% of the populace or voting population is registered Democrat, and yet they control 7 out of 8 congressional seats, which is 88% of the seats. And so that difference between your vote and what you control is the benefit or advantage of gerrymandering.
Wow. So we've mentioned kind of these two cases that Judicial Watch is involved in: Maryland's 3rd district, and then what's happening in Wisconsin. So let's take Maryland first. And if you'll allow me, there's a really good quote actually that we included in one of our press releases that accompanied one of our briefs, I think. And it's actually from an editorial from the Washington Post where they describe Maryland's 3rd district. They say the map mocks the idea that voting districts should be compact or easily navigable. The 8 districts respect neither jurisdictional boundaries nor communities of interest. To protect incumbents and for partisan advantage, the map has been sliced, diced, shuffled, and shattered, making districts resemble studies in cubism. And
that's probably an understatement.
And that's an understatement.
Yeah. You can go across the country and you can see this problem. And so the question is, what do you do about it? All district lines help somebody and hurt somebody.
Right.
All district lines are drawn in this country by a state legislature or by, sometimes by a redistricting commission, which in my personal opinion can be as partisan and loaded as a legislature. And that doesn't necessarily fix the problem. I don't think that it does. And so where you have partisans drawing district lines and where you have the opportunity to take advantage like this, you're going to have gerrymandering. Both parties do it, and the problem the legal problem in particular, is how do you tell the difference between gerrymandering that violates, allegedly, the United States Constitution, or gerrymandering that violates the law,
right,
and district line drawing that's just like any other district line drawing. And where to put that line is a very difficult problem. We had our own proposed solution at Judicial Watch, and that was to look at what they were doing to the districts. If the districts are non-compact, then you can say that there's gerrymandering going on, or at least it's very likely. Non-compact districts are the tools that map makers use to cheat. And I consider extreme gerrymandering, at least, I consider it definitely to be cheating. When you gerrymander, you're not persuading anyone to vote for you. You're using a mechanical manipulation or trick to get more seats. And so that's why it's cheating. What we proposed is that courts look at the compactness, which can be measured mathematically, and that they look at other violations of traditional districting criteria how many times local district lines or town lines or county lines are cut by a district, and look at those things and say that if there's a lot of that going on, then there's a lot of gerrymandering. We were not successful in court, but this hasn't prevented other plaintiffs from attempting their own theories about how to stop partisan gerrymandering.
So how does that relate to what's going on in Maryland? When we're talking about the Maryland case and we're talking about Judicial Watch's involvement there, what are we saying about Maryland's district, and what are we trying to do about it?
Well, there's two cases going on. Maryland's actually the second one.
Right.
In the state of Wisconsin,
okay,
there was a claim that the Republicans had gerrymandered, and I think by all reasonable accounts they had. In 2012, with 49% of the vote, Republicans had more than 60% of the Wisconsin Senate seats. And to be a minority and actually have a majority, that's as good as a gerrymander gets. In 2014, they actually had a majority by then of 52%, and they still had an overwhelming majority of seats. In that case, the district court, which was a three-judge court, and by district court, this is a way to refer to federal courts at the trial court level. That's where you start. That's where you bring your lawsuit. A three-judge panel of the district court ruled 2-1 that there was a gerrymander and that the plaintiff's theory about how to describe it was valid, and that went up on appeal to the Supreme Court, where it is now. In Maryland, initially, by a 2-1 ruling, it was decided that the plaintiffs had stated a claim, which means that they survive a motion to dismiss. Mm-hmm. And then when it came time for the plaintiffs to get an injunction, which is they said, look, you said we were going to win, or we might win. We want to enjoin the use and prevent the use of these districts in future elections.
Right.
By a 2-1 ruling, the court said, no, you haven't shown us that you're that likely to win. And so there, the parties arguing in favor of a remedy for gerrymandering appealed, and the Supreme Court heard oral argument in that case as well. So it has a couple of cases before it.
So Wisconsin and Maryland both
currently before the court.
Both before the court, sort of for different kind of different issues facing still both gerrymandering. So,
but what's remarkably similar is that they both the plaintiffs in those cases make sort of the same argument, the same kind of argument. It's not an argument I like. I think that there are a lot of problems with it.
So what is the specific argument that they are making?
Well, what they're trying to do is to get away from what we had focused on, which was, what are the map makers actually doing when they cheat?
Right.
And to look for that, look for smoke and say there's fire. What they do is say, look at the success of the gerrymander. See if Republicans win more seats than they were expected to win. See if Democrats win more than they were expected to win. And never mind the shape of the district. Now, the problem with that is, as we all know, several things can turn elections. Local issues, wave issues, national waves, local circumstances. I remember a mayor in Chicago was turned out of office because she didn't deal appropriately with a snowstorm. These sorts of things make it impossible. And if you think about it for a minute, you will believe this. It is impossible to determine why certain parties win and when they're going to win and how much they should win by. I mean, we saw this with President Trump's election.
Right.
That was not predicted. And so their approach, these plaintiffs, has been to get social scientists and experts to say, well, we think the margin ought to be this. And compared to what we think it ought to be, they've won more seats. So they must be cheating. That is a very hard standard to meet. And, to use that sort of, to my mind, junk science, certainly speculative science, to possibly ask a federal court to overturn a valid election is a terrible idea. Terrible.
So what you're referring to there is sort of an expected win approach. Sort of their remedy, if you want to call it that, to gerrymandering is for experts, experts, I guess in quotes, to say this is sort of what we think, which party we think should win and what we think they should win by. And if that's not happening, that's gerrymandering.
Yes.
That's sort of their sort of solution to this problem.
And I always like to describe things as they really are. So let's be clear. These are sociologists and political scientists who teach at colleges and universities. And they study politics and they come up with an estimate of what should happen. And based on that estimate, they're asking a federal court to order a state to ignore the results of an election that it held under district lines that it passed. That is very serious stuff. And it's being asked of the court. They haven't done it yet, but it's being asked on the basis of what I consider to be junk science. I will bet you that none of these experts picked Trump to win. Not one.
And he did. And that just kind of goes to show sort of the volatility of polling and expectedness and all of that. Is that
and just life. I mean,
and just life in general.
Yeah.
Yeah, you can't. It's not down to a science. We don't have these things down to a science. So Judicial Watch, we are saying that gerrymandering is a very real problem, but that sort of these social science guesstimates are not the way to solve it. So you referred earlier to sort of a traditional districting approach. So what does that look like? What does that solution to the gerrymandering problem look like?
Well, just know that traditional districting criteria is a phrase that has been used at the Supreme Court. And when the Supreme Court uses a phrase, lawyers use it too.
There you go.
It means something relatively simple. It means that the districts are relatively compact, and it means that they follow mostly local boundary lines, towns, counties, precincts. That's all that it really means. Compactness can be measured by any of a number of mathematical tests. There's one test that we favor, and we suggest that courts look at this in determining when a district is a mess. And it has great predictive power. It follows the eyeball test as well. If you looked at a shape and said that it was a mess, it would score very poorly. It's once you have this kind of, and the analysis of when a district is compact or non-compact is used in a number of court decisions. Social scientists use these numbers. These are established techniques, and they're primarily mathematical. It wouldn't, in my view, be a terrible idea to have a test for gerrymandering, like all good evidentiary tests that looked at everything. You can look at whether a party is winning more than was expected, as long as you also look at, is the district a mess? Does it intrude on other political entities? Are the boundary lines non-compact? Was the district drawn in secret by a committee composed of the other party? There are certain common sense things. Everyone knows when a district's been gerrymandered. Why restrict the evidence in any way at all? So look at traditional districting criteria. Consider what the social scientists have to say. But I would think to say gerrymander, you need an alignment of several kinds of evidence.
Yeah.
Because as I said, you're messing with the democratic process. You've got to be sure.
You got to be sure, and you have to make sure that you're sort of taking a broad approach to fixing it, because it's a broad problem. And ultimately, I think that there's a quote from Judicial Watch President Tom Fitton that said basically, with gerrymandering, you have politicians picking who their voters are going to be, instead of the voters picking the politicians. And so that's the problem with gerrymandering. But you also have to make sure that your solution isn't putting the power in someone else's hands. Ultimately, it's got to be in the hands of in the voters, the democratic process.
Well, yeah. Tom makes a great point. The way the newspapers traditionally cover gerrymandering, and certainly the way districts are drawn, it's portrayed as a fight between parties. The Democrats gerrymandered the Republicans. The Republicans gerrymandered the Democrats. That's not really the right way to look at it. What actually happens with the gerrymander is sitting members of the legislature take the power to pick who sits in the legislature next term from the people,
right,
and give it to themselves.
Right.
What's really going on is a transfer of power from voters to government. It does happen to go through the agency of the parties.
Exactly. And that's the real problem there, is that you have politicians taking away, and that's why we consider
It's a government problem. That's why it's a constitutional problem.
It's a government problem, a constitutional problem, and it's an election integrity problem because it's going to the very heart of whether your vote is actually having the impact that it should.
Yes.
So I think that we've covered, sort of what Judicial Watch is doing with gerrymandering. We have briefs at the Supreme Court sort of arguing our case, Wisconsin, Maryland. But Judicial Watch is also involved, like I said, in sort of other aspects of election integrity as well. The voter rolls.
Yes, the National Voter Registration Act.
The National Voter Registration Act, the NVRA. Politicians don't like fixing gerrymandering, and they don't like cleaning up the voter rolls either. Talk with me very briefly, if you will, about what Judicial Watch is doing in that area, because I know that we have a lot of sort of litigation going on and that sort of thing with a broad number of states. So if you could walk me through really quickly what we're doing about the voter rolls as well.
Sure. Well, there's a federal law, the NVRA, and the NVRA says states have to clean up their voter rolls. They have to make a reasonable attempt to do so. And the categories you particularly want to remove are, of course, voters who have died and voters who have moved out of state. And there are procedures set forth in this statute for doing this. States hate to do it. It costs money, it takes effort, and so you can get, by our count, 400 to 500 counties out of perhaps 3,000 counties nationwide who have more voter registrations than citizens of voting age in those counties, than 18 and older citizens who could even register to vote.
So more are registered than are even eligible to be voting. So obviously
eligible to register.
Eligible to even to register to vote. Yeah.
Correct.
A bit implausible.
Yes. Now, you can have that sort of thing on a temporary basis if you're trying to clean up your voter rolls. But when you've got states that have had these sorts of imbalances for years, they're just not doing anything. Now, we've sued a number of states. We've had success in Ohio. We sued Indiana, had success there. More recently, we've sued Kentucky and Los Angeles County and California for their failure to implement the procedures required by the NVRA to clean up the voter rolls and to get rid of people who've moved elsewhere. And so the lawsuit in California is particularly interesting insofar as what we're hearing from the local politicians is that we're totally wrong, they're doing nothing wrong, we've got it all backwards. They don't want to remove anyone from the rolls, apparently even if they've moved elsewhere. We expect to see, in fact, we've heard from our first proposed intervener, which is a liberal interest group, Demos, which wants to join the lawsuit and help defend the state against Judicial Watch. So
interesting. So when I was going through this and was sort of looking at all the different states that we were looking into, California was the one that sort of stood out to me. So before we get into sort of the nitty-gritty of what we're doing in California and what we're trying to bring to light, talk with me about why California is such a problem. What's going on there?
I mean, in a word, they've got a philosophy that you never remove people from the voter rolls. So, once you're on the voter rolls, you're there forever. They may check to see if you moved, or they may ask you if you moved, but if you don't respond or they don't get a response, they don't do anything. And they've as much as admitted that Now, there's a federal law saying they have to take reasonable steps, and so we're very confident about how that lawsuit is going to go. And we're in the middle of it, and we look forward to a judgment in our favor. The NVRA is a statute that people don't focus on a lot. It is a very important statute. It's typically called the Motor Voter Bill. It both provided for registration at departments of motor vehicles and provided that, sort of as a logical parallel to that effort, you have to clean your voter rolls and you have to check if people have moved out of state or have died. And those two should go together, maximum access for voters who are in state, and check to see if the voter rolls only contain registered voters. And the extent to which people fight the second part of that is astonishing. States fight it, interest groups fight it, and I've said before, I think there's something dishonest about enforcing only half of a compromise bill. But that is how states often treat the NVRA. Register as many people as you can and never take anyone off. And there are so many ways that can affect or increase voter fraud. An invalid registration can be voted. It can be voted by absentee ballot. It can be double voted. For example, someone in California moves to Nevada. They can come back across the border or even mail in their ballot and vote in California and then vote in Nevada. It has other consequences that perhaps aren't as obvious to people. One that I like to point out is that a lot of get out the vote efforts focus on mailing or contacting people who are on the voter rolls. Well, if you're contacting people on the voter rolls and they're not in the state anymore, you're wasting your time. You're wasting your money mailing to these people. So, more accurate get out the vote efforts will depend on enforcing the National Voter Registration Act.
So you're saying, so the NVRA provides for, voter access and that sort of thing, but it's also supposed to provide for some integrity in the process at the same time.
This isn't just my reading. It's in the purposes of the statute. It mentions both goals.
It's the purpose of the law,
yes,
is to achieve both those things. And by not enforcing it, not only does it open up the possibility of voter fraud taking place, but it also makes efforts...
Cuts against access.
But it cuts against access because and I say this as someone that in my previous life had worked on campaigns, is that a good get out the vote effort is having good data on that is key to making sure that people know when to vote and how to vote and where to vote. And you're saying if the NVRA isn't enforced, it can actually cut against those efforts, the efforts of people that want to make sure that people are getting out to vote.
Absolutely, yes.
Wow. That is actually an aspect of it that I hadn't really thought about before. But that's...
Well, the NVRA in its way it's bigger and, in my opinion, more important than the other important fight going on about voter ID. I think that, voter ID is important. I think that states should be allowed to adopt it. I think that it's a common sense measure, and we have to have ID to do so many things in life. And I'm all in on voter ID, but the NVRA is in a way more important. It impacts more kinds of potential fraud, including to some extent impersonation fraud, but there's several kinds of fraud that can be prevented or allowed depending on how well you enforce the NVRA, and it also affects access, as we were just talking about.
Yeah. So obviously, we have cases moving forward in various places. You mentioned in California, sort of other outside groups starting to get involved. Can you walk me through kind of where the case in California stands? Because it looks like to me that California is sort of the worst transgressor in this area. It's also by far and away the biggest state in the country. So this really matters. So what's the current state of affairs there, and kind of where's it going from here?
Well, we're in what lawyers call discovery, which is we're collecting documents, we're asking people statements under oath. Is this true? Is that true? Explain this to us.
Yeah.
And you get this information. From there, you proceed to take depositions, and from there you proceed to your lawsuit. So we're early in that process, in the discovery process. I'm happy to take that case to judgment. At the same time, I always tell people I'll always settle a case. Happy to do so, on terms that will provide that a state or locality do what federal law, I don't know, requires them to do anyway. And so I'm glad to settle a case. Where this is going to go, I don't know. Secretary Padilla, who was one defendant, and Dean Logan, who's the clerk, basically, of the Los Angeles County, they're talking tough and defiant, and I don't think that's warranted given the facts on the ground. But we'll take it either to court or we'll take it to settlement. So, it's hard to predict.
Awesome. Well, I think that you've provided sort of some insight there that's useful. And you're right about the NVRA sort of being a very, very important law for enforcing this sort of thing. So I think as the case progresses forward, and if and when other state cases get involved, I'll definitely have to bring you back so you can continue to keep us updated on our efforts there in California and,
Sure.
and across the country. So, well, thank you for walking us through all of that. Obviously, gerrymandering, sort of an issue that I think everyone on sort of both sides of the aisle can agree is a problem. Solutions are few and far between, mainly because it's not something that politicians really want to fix. But I am glad that you and the other attorneys here in the office are sort of bringing our thoughts up to the Supreme Courts that they can weigh in. By the way, are you able to make any sort of prediction? Or do you have any feeling about what the Supreme Court might end up doing when it comes to gerrymandering?
It's hard to know. In 1986, the Supreme Court first held that the court could consider gerrymander claims. Prior to that, they weren't even justiciable, which means that the court said it's too complicated for us.
Okay.
We will have nothing to do with these claims. 1986, they said, well, in theory, we might be able to have a claim. In 2004, the court said, in a sort of fractured opinion, we haven't found anything yet. And 4 out of 9 justices said, forget the whole thing. Let's go back to the old system where we don't even hear these cases. Justice Kennedy said, well, maybe there's a way. I don't know what it is. Perhaps it's under the First Amendment, perhaps it's under the 14th, but maybe there's a way to bring these claims. And relying on the hope that he gave, people continue to try to sue. And he's the deciding vote in a lot of ways. I think the court, without Justice Kennedy, is split 4-4 on this issue. He gave an indication in one of the oral arguments, the first oral argument in Wisconsin, that maybe he would go for some sort of remedy suggested by the plaintiffs. And it's reading tea leaves, and it's not accurate most of the time. Some of the time, I don't know. But what he said was, he asked counsel, what would happen if a state passed a law saying you have to consider partisan advantage? You have to, when you redistrict, help the Democrats. And the lawyer said, well, that would be against the law. That would be a violation of the First Amendment. And his question was, well, how is this different? And the best answer was, well, this isn't facially attacking any party or any set of beliefs. It's just a bunch of metes and bounds. To which I guess a sort of response is, well, those metes and bounds help one party and hurt the other, and that's what they were intended to do. More recently, in the Maryland case, he asked an equally difficult question of the other side. He said, suppose that there were 2 parties, he called them Orange and Green, and suppose that Orange had a 55% majority to 45, and they drew districts that reflected that. And then there was an election in which Green came out on top, 55 to 45. And Green now seeks to redistrict to reflect the new reality.
Right.
55-45. Would that violate the Constitution? And the lawyer for the plaintiffs said yes, it would. And sort of the reaction of a number of justices was, isn't there something wrong with that? You know, the problem gets back to the problem with these plaintiffs' theory. They're looking at what people intended.
Right.
I want to look at what they did.
Right.
You know, if they also intended it, that's good evidence. But what did they do? Not what were they thinking? So.
And people change their minds, and these voting patterns change and that sort of thing. So,
absolutely, and you know, local conditions and all politics is local, as the saying goes.
Right. Interesting. All right. Well, I'll definitely have to have you back then to kind of follow up with if the Supreme Court lands somewhere, where they end up landing on that. So. So thank you very much for kind of walking us through what Judicial Watch is doing on gerrymandering, what we're trying to do with voter rolls, sort of election integrity in general. It's interesting. It's useful to have you on.
Well, thanks for having me.
Yeah,
anytime.
Glad to have you. And please make sure to continue to follow all of the work that Attorney Popper, all the other attorneys here, all the other investigators here at Judicial Watch that we're doing here. You can follow us on Facebook, follow us on Twitter, follow us on Instagram, follow us on YouTube. You can always, of course, visit judicialwatch.org as well for issues of election integrity and everything else that we're doing. We're going to continue fighting for you because no one is above the law. So until next time, I'm Jerry Dunleavy for Inside Judicial Watch. Thanks for joining us.